Welcome back, everybody, to the On the Docket podcast. I return for the fourth episode to discuss yet another case in the long and storied history of criminal justice law in the United States. For this episode, we are once again going to examine the constitutionality of the death penalty. This case is one of 5 cases that's known as the death penalty cases. Today, we will discuss Proffitt v. Florida. On the night of July 9, 1973, Charles William Proffitt went to work wearing a white shirt and a pair of gray pants, according to his wife. Somebody who worked with Proffitt claimed that during the morning of July 10th, he and Proffitt were out drinking until about 3:30 to 3:45 in the morning. Afterward, Proffitt drove his coworker home, still wearing the white shirt and gray pants. At about 5 in the morning, a woman called Mrs. Medjbo woke up in her home to find her husband, Joel Medjbo, sitting upright in the bed and moaning. Joel was holding what Mrs. Medjbo thought was a ruler. A third person, who Mrs. Medjbo hadn't seen, jumped up and beat Mrs. Medjbo with her fist, knocking her to the ground. The unknown third person then ran out of the house. Mrs. Medjbo didn't see her attacker, but she did get a good enough look to be able to describe him. Proffitt's wife maintained that her husband returned home at 5:15 a.m., wearing the same gray pants and white shirt, but no shoes. The two of them had a brief conversation before Proffitt packed up his clothes and left. According to the woman who was staying with the couple at the time, she overheard a conversation between Charles and his wife in which Charles admitted to killing a man and beating a woman while burglarizing their home. After all was said and done, there was one death that occurred during the break-in of the Medjbo's home, that of Joel Medjbo. What Mrs. Medjbo thought was a ruler was actually a butcher's knife, and Joel had been mortally wounded. With all of this evidence, Charles Proffitt was charged with first-degree murder. At trial, Charles's jury found him guilty of first-degree murder. Following Florida state law, a separate hearing was held to determine whether Charles would receive a life sentence or the death penalty. Per Florida state law, this decision is made when both a jury and the judge weigh 8 statutory aggravating factors against 7 statutory mitigating factors. The aggravating factors to be considered are as follows. 1. The capital felony was committed by a person under sentence of imprisonment. 2. The defendant was previously convicted of another capital felony or of a felony involving the use or threat of violence to the person. 3. The defendant knowingly created a great risk of death to many persons. 4. The capital felony was committed while the defendant was engaged or was an accomplice in the commission of, or an attempt to commit, or flight after committing, or attempting to commit any robbery, rape, arson, burglary, kidnapping, or aircraft piracy, or the unlawful throwing, placing, or discharging of a destructive device or bomb. 5. The capital felony was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody. 6. The capital felony was committed for pecuniary gain. 7. The capital felony was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of laws. And 8. The capital felony was especially heinous, atrocious, or cruel. And the mitigating factors to be considered are as follows. 1. The defendant has no significant history of prior criminal activity. 2. The capital felony was committed while the defendant was under the influence of extreme mental or emotional disturbance. 3. The victim was a participant in the defendant's conduct or consented to the act. 4. The defendant was an accomplice in the capital felony committed by another person and his participation was relatively minor. 5. The defendant acted under extreme duress or under the substantial domination of another person. 6. The capacity of the defendant to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. And 7. The age of the defendant at the time of the crime. During Proffitt's sentencing hearing, it was revealed that he had a prior conviction in 1967 for breaking and entering into a separate home. This hearing also included testimony from Dr. Crumley, who was the physician at the jail where Proffitt was staying during trial. Crumley testified that Charles came to him and told him that he feared he might harm other people in the future. According to Dr. Crumley, Proffitt himself confessed that he had an irresistible urge to kill that had already resulted in the death of one man, and he was afraid he might become violent again if he did not receive psychiatric help. In Crumley's estimation, Charles did pose a threat to his fellow inmates, but he also thought that he could be treated. Following the hearing, the jury returned an advisory verdict recommending the death penalty. An advisory verdict is a non-binding verdict, meaning if the judge didn't want to hand down the death penalty, they were not required to do so. It is very important to know that in this case, Florida law classifies the trial judge as the sole sentencing authority regarding death penalties. The judge ended up agreeing with the jury and sentenced Charles to death. An independent psychiatric exam found that Charles was not mentally impaired. Florida's death penalty procedure requires the judge to write an explanation as to why they sentenced the defendant to death. This explanation is automatically reviewed by the Florida Supreme Court before the defendant's scheduled execution. In the written explanation, the trial judge explains that they found 4 aggravating factors. 1. The murder was premeditated and occurred during a felony. 2. Proffitt had a propensity to murder. 3. The murder was especially heinous, atrocious, and/or cruel. And 4. Proffitt knowingly put a great many others in harm's way with his actions. The trial judge found no mitigating factors in the circumstances regarding the murder. Upon automatic review, the Florida Supreme Court upheld Proffitt's sentencing. Because Proffitt's sentencing was upheld by the highest court in the state, when he appealed his case, there was no court to appeal to besides the U.S. Supreme Court. All of the cases we've covered so far have gone through district courts, then appellate courts, then the Supreme Court. However, for the reason I mentioned just a few moments ago, this case was appealed directly to the Supreme Court. So when Proffitt appeals his case to the Supreme Court, he appeals on 2 aspects of his conviction. The first aspect is that Proffitt feels that the death penalty itself is a violation of his Eighth Amendment rights because he believes the death penalty is a cruel and unusual punishment. The other aspect of his conviction that Proffitt has a problem with is the manner in which he was convicted. Proffitt believes the Florida sentencing procedure is unconstitutional. He says that the sentencing procedure is arbitrary and capricious because the judge acts as the sole sentencing authority. Proffitt compares the Florida sentencing procedure to the Georgia sentencing procedure, pointing out that in Georgia, juries act as the sentencing authority with regards to the death penalty. It's also important to know that during this time, many death penalty convictions were being challenged in the Supreme Court, and a few of those challenges were coming out of Georgia. So who are the justices that are going to hear Proffitt's case? The first thing to note is that this case was heard by the Burger Court, meaning that Justice Warren Burger was the Chief Justice at the time. Burger was nominated by President Richard Nixon on May 23, 1969, to replace the retiring Chief Justice Earl Warren. Burger was critical of Warren's time on the court because Burger was a constructionist whereas Warren was not. Constructionism is the judicial philosophy that the Constitution should be interpreted as literally as possible, that it is not a living document whose meaning changes with time. Nixon promised his supporters that he would nominate a constructionist to the court, so he did with Burger. Burger was confirmed to the court in June of 1969. On the topic of criminal law as well as criminal procedure, Burger was known to be a reliably conservative vote. During his time on the court, Burger's practices as Chief Justice ended up angering a lot of his colleagues to the point where many of them lost respect for him altogether. Burger would sometimes switch his opinion or not announce his opinion simply so that he would have the ability to write the majority opinion. By the time Burger retired from the court in 1986, he had alienated all of the other justices. Next up is Associate Justice William Brennan, Jr. Brennan was nominated by President Eisenhower shortly after the 1956 presidential election. Brennan was meant to replace the retiring Associate Justice Sherman Minton. Eisenhower nominated Brennan because Eisenhower was a Republican and his advisors thought it would quell the voices of his critics if he nominated a Democrat to the High Court. Brennan's nomination was met with a bit of criticism for 2 reasons. The first was that Brennan was a Roman Catholic and some people feared that he would rely on his religious beliefs to make his decisions. The other criticism came from the McCarthyists, who attacked Brennan for calling anti-communist investigations witch hunts. Brennan was given a chance to defend himself, and in the end he was confirmed to the court with the only dissenting vote coming from Senator McCarthy. On the court, Brennan found himself amongst the liberal bloc of justices, which was relatively small during the years of the Burger Court. Brennan also played a fairly significant role in convincing his conservative colleagues toward more liberal opinions. Regarding the death penalty, Brennan was an ardent opponent of it. Following Justice Brennan Jr., we have Associate Justice Potter Stewart. Stewart was another Eisenhower-nominated judge, and he was meant to replace Justice Harold Burton. Stewart was confirmed to the court in 1959 on a 70-17 vote. On the court, Stewart seemed to be a moderate and often found himself as a swing vote when the liberal and conservative blocs couldn't agree. Even on cases regarding the death penalty, Stewart was known to vote in favor of it as well as against it, depending on the case. We also have Associate Justice Byron White. Byron White was nominated by John F. Kennedy in 1962 because the Kennedy administration admired White's intellect and modesty. White was meant to replace the retiring Associate Justice Charles Whittaker, and in the same year that he was nominated, he was confirmed. Justice White's judicial style has been hard to pin down or categorize because he has authored so many opinions, some of which are liberal and some of which are conservative. Regarding the death penalty, Byron White was similar to Potter Stewart in that both of them voted in favor and in opposition to it in different cases. However, regarding criminal law and procedure, White found himself eye to eye with Justice Burger. After that, we have Associate Justice Thurgood Marshall. On June 13, 1967, President Lyndon B. Johnson nominated Thurgood Marshall to replace the retiring Justice Tom Clark. He was confirmed to the court in the same year by a 69-11 vote. On the court, Marshall served as a reliable liberal vote, and he and Justice Brennan became outspoken opponents of the death penalty. Along with Justice Marshall, we have Associate Justice Henry Blackman. Blackman was a Nixon-nominated judge, and in 1970 he was confirmed to the court by a vote of 94-0. Blackman was Nixon's third in line to replace the retiring Justice Abe Fortas. Nixon's first two nominees, Clement Haynsworth and George Carswell, failed to win the Senate over. Blackman was recommended by Nixon by Warren Burger, who was the Chief Justice at the time. Burger recommended Blackman because Blackman had been a Republican all his life, and Burger generally agreed with Blackman on most topics. As expected, Blackman started off his time in the court as a reliably conservative vote. However, as the years wore on, Blackman found himself voting with Burger less and less, instead choosing to vote with the liberal bloc of justices. With the first few death penalty cases that were heard by the Supreme Court, Blackman was an avid supporter of capital punishment. However, as he became more liberal, he became far less favorable of it. After Justice Blackman, we have Associate Justice Lewis Powell, Jr. Nixon initially asked Powell if he wanted to join the court in 1969, but he turned the offer down. Nixon asked him again to join the court in 1971, and with some careful persuasion by Attorney General John Mitchell, Powell accepted. Nixon nominated Powell to replace the retiring Justice Hugo Black. On December 7, 1971, Powell was nominated to the court on an 89-1 vote. Regarding the death penalty, Justice Powell played a powerful role in bringing the sharply divided justices to compromise. Moving on from Justice Powell, we have Associate Justice William Reinquist. Reinquist was another Nixon-nominated judge, and on the same day that Nixon nominated Lewis Powell, he also nominated William Reinquist to take the spot of the retiring Justice John Harlan II. On December 10, 1971, a day after Powell's confirmation, Reinquist was approved to the highest court on a 68-26 vote. During the years of the Burger Court, Reinquist was known for being the most conservative judge on the court. Reinquist was also an avid supporter of the death penalty. Finally, we have Associate Justice John Stevens. In 1975, President Gerald Ford nominated John Stevens to replace the retiring Justice William Douglas. On December 19, 1975, John Stevens was confirmed to the Supreme Court on a 98-0 vote. Justice Stevens was a registered Republican, but his views on the death penalty changed depending on the circumstances of the case. So, now that we've discussed the justices that will be hearing the case, let's get into the oral arguments. The first highlight I want to mention is when Proffitt's representation, which is Clinton Curtis, explains to the judges what Florida's capital sentencing procedure is. He says, "The statutes of Florida provide that a life sentence will be imposed upon a conviction for a capital felony and consisting of not less than 25 years without the hope of parole, and this capital felony is defined as premeditated murder or murder during the commission of 8 enumerated felonies, and there is another capital felony which is rape of a child 11 years or under. But the imposition of the life sentence is mandatory unless the death penalty is determined and imposed pursuant to the new Death Penalty Act. This act provides for a bifurcated procedure. Upon conviction for a capital felony, a sentencing hearing is conducted before the same trial jury in order to obtain advice and advisory recommendation of life or a death sentence. No reasons need to be given in the verdict returned by the jury. It simply is a statement that we, the majority, have determined to recommend either life or death, and that is basically the form of the verdict that's given to the judge. The trial judge may, notwithstanding the jury's recommendation and or either a sentence of life or death. If he imposes death, he is required to file written findings in support of his sentence. The statute requires review of all death sentences by the Supreme Court of Florida. 8 aggravating and 7 mitigating circumstances is set forth from the statute for the consideration of the sentencer, the jury for advisory purposes, the trial judge for sentencing purposes. On the 26th of July of 1973, the Supreme Court of Florida held this particular act constitutional, acknowledging that there is a discretion in the sentencing procedure, but that this discretion possible and necessary was reasonable and controlled, and thereby complied with the test of Furman versus Georgia. The petitioner was charged in July of 1973 and was convicted in March of 1974 of premeditated murder of Joel Medjbo by stabbing. The jury recommended and the trial judge imposed a death sentence. The petitioners claimed that statute was unconstitutional and was rejected on the authority of the early decision on State versus Dixon. We submit that death sentences imposed under the statute are arbitrary because they may be and have been based on non-statutory enumerated factors and at the controlled discretion of the sentencers permitted and required to interpret or evaluate and apply the statutory circumstances. Now, in the petitioner's case, the trial judge found and set forth in his written findings 4 aggravating circumstances. One of these circumstances was that the defendant had the propensity to commit the crime for which he was being charged and that he was a danger and menace to society. This is not one of the statutory enumerated aggravating circumstances. By affirming this death sentence, the Florida Supreme Court approved the concept, Chief Justice. I included this excerpt because I think it's important for several reasons. The first being that it explains Florida's capital sentencing procedures better than I could, and the second reason is because Curtis brings up a very interesting argument here. He says that according to the Florida statute, the judge is only supposed to consider the 8 aggravating and 7 mitigating statutory factors. However, in the judge's written explanation of why they chose to sentence Charles Proffitt to death, they mention that he has the propensity to commit the crime that he was charged with and that he was a menace to society. Yet, this wasn't one of the statutory factors that they were supposed to consider, regardless of whether it's aggravating or mitigating. Clinton even goes so far as to say that because the Florida Supreme Court affirmed Proffitt's death sentence, they by proxy also affirmed the judge's citing of his propensity to commit the crime for which he was being charged, even though under Florida statute he technically wasn't supposed to consider that when sentencing Proffitt. Clinton's argument here is that if the judge is acting as the sole sentencing authority and they can sentence someone to death for circumstances that they were never meant to consider, then that technically means that judges are acting as uncontrolled sentencing authorities and that there is the chance of inconsistency regarding why one defendant might be given life whereas the other might be given death. Later on, one of the justices questions Clinton as to why he bothered to mention the non-statutory circumstance, his propensity to commit crime, that was included in Proffitt's death sentence if there were also 3 statutory aggravating factors that were included in the judge's explanation of his sentencing. To that end, Curtis responds, "If the trial judge felt that the 3 aggravating circumstances were sufficient to support his position that the death sentence should have been imposed, why was it necessary for him to come forward and come with a non-statutory aggravating circumstance?" And this will become more relevant as we get into the discussion of sufficiency, which is this weighing process that Florida requires, and it is somewhat different than any of the other statutes that had been thus far presented. By this point, Chief Justice Burger starts to understand what Curtis's argument is here, and he confirms this when he asks, "Your position is that now the reviewing court then and now had no way of knowing whether that might have been the dominant one or the decisive one. Is that your point?" And Curtis confirms that this is indeed a fair assessment of what he is trying to say. The next part I want to bring attention to is the portion of the oral arguments where Clinton argues that the statutory mitigating and statutory aggravating factors are both arbitrary and somewhat baseless. Curtis says, "Now, according to the statute, the sentencer determines whether sufficient aggravating or mitigating circumstances exist and whether the mitigating outweigh the aggravating circumstances. Nowhere in the statute do we have a definition of the term sufficient. The weight or relative significance of a circumstance or a combination thereof is likewise not in the statute. We're not told that this circumstance has more weight or is entitled to more weight than any other. In other words, the presence or absence of any such circumstance or combination does not compel a particular result. This is somewhat different than the federal statute, where you have aggravating circumstances, and if that is found to exist, such and such result will occur, and then if a mitigating circumstance exists, such and such result will occur. There is no such definition in our statute. The Supreme Court of Florida has stated that its responsibility in this overall process, and mind you, the statute does not define what the Supreme Court's responsibility is, but the Supreme Court has defined that it is to review a death sentence case in the light of facts presented in evidence as well as other decisions and determine whether or not the sentence of death is too great. And no opinion that has been rendered by the Supreme Court of Florida thus far affirming a death sentence explains why a less harsh penalty would not be sufficient. Nor does any opinion compare a death sentence case with the many life sentences imposed for basically the same or substantially the same type of conduct. Such a comparative review is impossible. It is frankly impossible since the many life sentences are reviewed, if at all, not by the Supreme Court of Florida, but by the District Courts of Appeal. Another judge asks, does that death sentence go directly to the Supreme Court of Florida, to which Curtis responds, yes. At this point, Chief Justice Burger asks if all death sentences are reviewed by the Supreme Court of Florida as a matter of right. Clinton Curtis responds with, as of statutory direction, it goes all death sentences whether I assume the defendant wishes or not. It will automatically be reviewed by the Supreme Court of Florida. But in situations where life sentences were imposed for capital felonies, if they were reviewed at all, they go to the District Courts of Appeal. So this point is pretty interesting, I think, because Curtis brings attention to the fact that while impositions of the death penalty are automatically reviewed by the Supreme Court of Florida, impositions of a life sentence are reviewed by the District Court of Appeal, if they are reviewed at all. Curtis is pointing this out because he's trying to prove that the capital sentencing procedure of Florida is arbitrary and therefore unconstitutional. He tries to prove that by showing the two different standards given to defendants sentenced to life and defendants sentenced to death. So those are some major points made by Curtis that I wanted to highlight. After Curtis, Robert Chevin, who is representing Florida in this case, begins his oral argument. Chevin comes out swinging and almost immediately goes after the non-statutory aggravating factor that Curtis mentioned, which was Proffitt's propensity to commit this sort of crime. Regarding this non-statutory aggravating factor, Chevin says, counsel talked about propensity, and he said that this was an issue that came to the attention of the judge and the jury and had nothing to do with the aggravating circumstances enumerated in the statute, and the Chief Justice at that point said, well, how did they determine propensity or whether he would be a danger to society? Very simply, he said he will kill again. We have a testimony in the record of the psychiatrist, and he was asking him, this was subsequent to the trial, the psychiatrist at the hearing testified this after they waived confidentiality. He felt that he would do damage to people in the future, that he already had done damage to the people that he had killed, and as a matter of fact, on page 423 of the testimony, quote, furthermore, he was having similar feelings beginning to build up in the cell in which he was confined, and he felt this degree of hostility being directed towards a specific inmate. He told the doctor, and this was part of the testimony that the judge and jury heard on whether or not he should get death or life, he told the doctor he was going to kill again, that he had this urge to kill again, that he might even kill an inmate in the jail cell, unquote. Now, why shouldn't a judge be able to consider that? Now, when that came to the Florida Supreme Court, they recognized that that was not one of the enumerated aggravating circumstances, but the Florida Supreme Court, through maturing case law on this subject, has, in effect, in several of these cases, expanded the aggravation and expanded mitigating circumstances. As a matter of fact, in the Gardner case, they say that a PSI saying that someone is going to be a menace to a society can be considered. In the Hallman case, they said the fact that the defendant was non-rehabilitatable can be considered. In our case, in the Proffitt case, the propensity to commit another crime was added aggravating circumstances. In the Sawyer case, Sawyer said he was going to kill the judge. He said, when I get out of the prison, I'm going to kill a judge, I'm going to kill a prosecutor. So this judicial threat was considered as an additional aggravating circumstance. That's when another judge asks, Mr. Attorney General, just so I understand, the non-statutory additional aggravating circumstances is not a substitute for statutory circumstance, just additional fact that may be considered. To which Chevin answers, Your Honor, the statute says that they can consider all relevant material. The Supreme Court has said anything that is relative of probative value and has not been admitted in violation of the Constitution of the United States or Florida can be considered as long as it deals with either aggravation or mitigation. After Chevin says this, another justice asks for clarification, asking, but it remains true that one of the 10 statutory, or whatever the number is, aggravating circumstances must be filed, and Shevin confirms that at least one of the aggravating circumstances must be statutory. Shevin then goes even further and says, as a matter of fact, I want to point out the fairness of this procedure because the Supreme Court of Florida has also found some non-enumerated mitigating circumstances. Again, relevancy is the key. In the Slater case, they reduced it from death to life because a co-conspirator had gotten life and they felt it was unfair to give one of them death when the other one got life. So that was the basis of reducing it by the Florida Supreme Court. In the Taylor case, there was a question as to whether he actually pulled the trigger. They were not sure he pulled the trigger, and as a result they reduced it because they were not sure he was the trigger man. In the Gardner case, they said intoxication is an unenumerated mitigating circumstance. In the Swan case, it was a non-deliberate killing. It was a felony murder, and they beat this woman, but they said there was no evidence that they intended to kill her. They put her in a closet, and because of a pre-existing medical condition, she died in the closet, and the Supreme Court of Florida said that it was basically a non-deliberate felony killing, and as a result, it could be mitigated. In the Proffitt case, what we are dealing with here is a danger to society. He will kill again by his own statement. He has a propensity to kill. He has an uncontrollable appetite to kill, which is not synonymous with diminished mental capacity. This has been testimony in the record by 2 psychiatrists that he understood the criminality of his act. There was not one mitigating circumstance, and there were 4 aggravating circumstances. So I thought this was important to bring up because it seemed to me that in Curtis's arguments, he really tried to hammer home the point that there were inconsistencies in Florida's capital sentencing procedure that arose from the trial judge's ability to cite non-enumerated aggravating circumstances when sentencing Proffitt to death. Interestingly enough, Shevin doesn't deny this. Instead, he leans into it and says, yes, judges do use non-statutory aggravating circumstances, but the Supreme Court of Florida has allowed that, and they even allow justices to list non-statutory mitigating circumstances, which I think is kind of an interesting and nuanced way to handle the argument. Afterward, Justice Reinquist asks, how about your opponent's contention that there is finding in the life cases that they really never get to the Supreme Court of Florida because they entered the District Court of Appeal? To this, Shevin responds, well, as I pointed out a moment ago, Sir Mr. Justice Reinquist, the Supreme Court of Florida has said, quote, we want the judges to enter written findings, even in the life cases, and they have been traditionally argued, unquote. Every time someone comes to the Supreme Court of Florida, if they think there is a life case similar to theirs that ought to get them life rather than death, they rely on it very heavily, and those are reported cases in the Southern Reporter, and they are available to the Supreme Court of Florida. Even though they are not reviewed by the Supreme Court of Florida, we contend that they are available and are considered by the Supreme Court of Florida. Afterwards, Shevin goes on to list several cases in which a defendant who was originally sentenced to death in Florida was given life upon review by the Supreme Court of Florida. Again, though, Shevin is not denying Curtis's argument. He says that yes, life sentences are reviewed by the District Court of Appeals, and yes, death sentences are reviewed by the Supreme Court of Florida. However, this does not make the process arbitrary, because if an inmate is sentenced to death by a trial judge, but the circumstances surrounding his crime were similar to the circumstances surrounding the crime of another defendant who is sentenced to life, that defendant can argue that point before the Supreme Court of Florida. It may be a little difficult to wrap your head around that at first. It certainly was for me, but I hope I made it make a little bit more sense. Shevin goes on to make a vehement plea to the justices to affirm Proffitt's sentence. He says, if the Eighth Amendment argument that he says applies only in capital cases, logically, legally, you cannot apply that only in capital cases. True death is different, but the Eighth Amendment doesn't apply just to capital cases. The Eighth Amendment applies and has traditionally been applied to less than capital cases, and the due process provision talks about life, liberty, or property. And if you're going to deprive somebody of life and you are going to say, we cannot do that because there is prosecutorial discretion, jury discretion, executive clemency, etc., I submit to you that that same argument applies to a lifer. And even though Mr. Amsterdam stands before this court and says, I am only trying to apply it in death cases, there is no way he can foreclose someone who is under a life sentence coming back to this court and saying, give me that same protection. Equal justice under law. That is what the front of the building says, and that is exactly what a lifer is going to say. That is exactly what a man under 5 years, 20 years, or 99 years is going to say. he is going to say that if you say the whole system is wrong, then it is wrong to him as well. And for those reasons, we urge you to affirm this conviction to state, in effect, that the whole system is not wrong, to state that capital punishment is not cruel and unusual per se, and that it cannot be applied as an Eighth Amendment violation just in capital cases so as to attack, in effect, the entire criminal justice system. So, in his last rallying cry argument here, Shevin says that what Proffitt is doing is attacking the Eighth Amendment as a whole, not just the idea of capital punishment. Certainly he is making the argument that the death penalty as a whole is a violation of the Eighth Amendment, but his larger goal is to get the judges to say that the whole system is wrong. Whether you agree or disagree with this is up to you, but Shevin is asking the judges to uphold Proffitt's sentencing and warns them that if they don't, they're going to see a whole host of other Eighth Amendment cases coming to the courts as inmates try to dismantle the Eighth Amendment. Now, Clinton Curtis reserved the last few minutes of his speaking time for a rebuttal, and after Shevin's oral argument is over, Curtis makes one last point to the justices. He says, "It seems inconceivable to me that in Swan v. State, where you have what is described by the trial judge as an outrageous, wicked, wild, atrocious, cruel, and heinous crime committed during the course of a robbery that was the beating death of an elderly housekeeper, and the Supreme Court, in light of those two aggravating circumstances, takes a position that, and I quote, there were insufficient aggravating circumstances to justify the imposition of a death penalty," unquote. Now, if we are going to have standards, which Attorney General Shevin is suggesting that these are supposed to be, we are going to have standards. What is good for Swan is good for Mr. Proffitt, and if we are going to be measured by the jury, the sentencer, or the Supreme Court of Florida, we ought to be measured by the same rules, and that is what we are talking about when we say justice under the law. So again, what we have here is Curtis making the argument that the standards Shevin described in his arguments are not standards at all, but rather discrepancies. Now, before we get into the opinions, I want to remind everybody of the constitutional questions being asked here, which are, is the death penalty a cruel and unusual punishment, and is Florida's capital sentencing procedure unconstitutional? Well, in a 7-2 vote, the Supreme Court answered no to both questions. The plurality opinion was written by Justice Powell and joined by Justices Stewart and Stevens. There was a concurring opinion by Justices White, Reinquist, and Chief Justice Berger. There was a separate concurring opinion from Justice Blackman and 2 dissents from Justices Brennan and Marshall. I am first going to read the plurality opinion delivered by Justice Lewis Powell and joined by Justice Potter Stewart and Justice John Stevens. The opinion goes as follows. The petitioner, Charles William Proffitt, was tried, found guilty, and sentenced to death for the first-degree murder of Joel Medjbo. The circumstances surrounding the murder were testified to by the decedent's wife, who was present at the time it was committed. On July 10, 1973, Mrs. Medjbo awakened around 5 a.m. in the bedroom of her apartment to find her husband sitting up in bed, moaning. He was holding what she took to be a ruler. Just then, a third person jumped up, hit her several times with his fist, knocked her to the floor, and ran out of the house. It soon appeared that Medjbo had been fatally stabbed with a butcher knife. Mrs. Medjbo was not able to identify the attacker, although she was able to give a description of him. The petitioner's wife testified that on the night before the murder, the petitioner had gone to work dressed in a white shirt and gray pants, and that he had returned at about 5:15 a.m. dressed in the same clothing but without shoes. She said that after a short conversation, the petitioner had packed his clothes and departed. A young woman boarder who overheard parts of the petitioner's conversation with his wife testified that the petitioner had told his wife that he had stabbed and killed a man with a butcher knife while he was burglarizing a place, and that he had beaten a woman. One of the petitioner's co-workers testified that they had been drinking together until 3:30 or 3:45 on the morning of the murder, and that the petitioner had driven him home. He said that the petitioner at this time was wearing gray pants and a white shirt. The jury found the defendant guilty as charged. Subsequently, as provided by Florida law, a separate hearing was held to determine whether the petitioner should be sentenced to death or to life imprisonment. Under the state law, that decision turned on whether statutory aggravating circumstances surrounding the crime outweighed any statutory mitigating circumstances found to exist. At that hearing, it was shown that the petitioner had one prior conviction, a 1967 charge of breaking and entering. The state also introduced the testimony of the physician at the jail where the petitioner had been held pending trial. He testified that the petitioner had come to him as a physician and told him that he was concerned that he would harm other people in the future, that he had had an uncontrollable desire to kill that had resulted in his killing one man, that this desire was building up again, and that he wanted psychiatric help so he would not kill again. Dr. Crumley also testified that, in his opinion, the petitioner was dangerous and would be a danger to his fellow inmates if imprisoned, but that his condition could be treated successfully. The jury returned an advisory verdict recommending the sentence of death. The trial judge ordered an independent psychiatric evaluation of the petitioner, the results of which indicated that the petitioner was not, then or at the time of the murder, mentally impaired. The judge then sentenced the petitioner to death. In his written findings supporting the sentence, the judge found as aggravating circumstances that 1. The murder was premeditated and occurred in the course of a felony, which was a burglary. 2. The petitioner has the propensity to commit murder. 3. The murder was especially heinous, atrocious, and cruel. And 4. The petitioner knowingly, through his intentional act, created a great risk of serious bodily harm and death to many persons. The judge also found specifically that none of the statutory mitigating circumstances existed. The Supreme Court of Florida affirmed, "We granted certiorari to consider whether the imposition of the death sentence in this case constitutes cruel and unusual punishment in violation of the 8th and 14th Amendments. The petitioner argues that the imposition of the death penalty under any circumstance is cruel and unusual punishment in violation of 8th and 14th Amendments. We reject this argument for the reasons stated today in Gregg v. Georgia. In response to Furman v. Georgia, the Florida legislature adopted new statutes that authorize the imposition of the death penalty on those convicted of first-degree murder. At the same time, Florida adopted a new capital sentencing procedure patterned in large part on the Model Penal Code. Under the new statute, if a defendant is found guilty of a capital offense, a separate evidentiary hearing is held before the trial judge and jury to determine his sentence. Evidence may be presented on any matter the judge deems relevant to sentencing and must include matters relating to certain legislatively specified aggravating and mitigating circumstances. Both the prosecution and the defense may present an argument on whether the death penalty shall be imposed. At the conclusion of the hearing, the jury is directed to consider, quote, whether sufficient mitigating circumstances exist which outweigh the aggravating circumstances found to exist, and, based on these considerations, whether the defendant should be sentenced to life imprisonment or death. The jury's verdict is determined by a majority vote. It is only advisory. The actual sentence is determined by the trial judge. The Florida Supreme Court has stated, however, that, quote, in order to sustain a sentence of death following a jury recommendation of life, the facts suggesting a sentence of death should be so clear and convincing that virtually no reasonable person could differ. The trial judge is also directed to weigh the statutory aggravating and mitigating circumstances when he determines the sentence to be imposed on a defendant. The statute requires that if the trial court imposes a sentence of death, quote, it shall set forth in writing its findings upon which the sentence of death is based as to the facts. A, that sufficient statutory aggravating circumstances exist, and that there are insufficient statutory mitigating circumstances to outweigh the aggravating circumstances, unquote. The statute provides for automatic review by the Supreme Court of Florida of all cases in which a death sentence has been imposed. The law differs from that of Georgia in that it does not require the court to conduct any specific form of review. Since, however, the trial judge must justify the imposition of a death sentence with written findings, meaningful appellate review of each such sentence is made possible, and the Supreme Court of Florida, like its Georgia counterpart, considers its function to be to, quote, guarantee that the aggravating and mitigating reasons present in one case will reach a similar result to that reached under similar circumstances in another case. If a defendant is sentenced to die, this court can review that case in light of the other decisions and determine whether or not the punishment is too great, unquote. On their face, these procedures, like those used in Georgia, appear to meet the constitutional deficiencies identified in Furman. The sentencing authority in Florida, the trial judge, is directed to weigh 8 aggravating factors against 7 mitigating factors to determine whether the death penalty shall be imposed. This determination requires the trial judge to focus on the circumstances of the crime and the character of the individual defendant. He must, inter alia, consider whether the defendant has a prior criminal record, whether the defendant acted under the duress or under the influence of extreme mental or emotional disturbance, whether the defendant's role in the crime was that of a minor accomplice, and whether the defendant's youth argues in favor of a more lenient sentence than might otherwise be imposed. The trial judge must also determine whether the crime was committed in the course of one of several enumerated felonies, whether it was committed for pecuniary gain, whether it was committed to assist in an escape from custody or to prevent a lawful arrest, and whether the crime was especially heinous, atrocious, or cruel. To answer these questions, which are not unlike those considered by a Georgia sentencing jury, the sentencing judge must focus on the individual circumstances of each homicide and each defendant. The basic difference between the Florida system and the Georgia system is that in Florida, the sentence is determined by the trial judge rather than by the jury. This court has pointed out that jury sentencing in a capital case can perform an important societal function, but it has never suggested that jury sentencing is constitutionally required, and it would appear that judicial sentencing should lead, if anything, to even greater consistency in the imposition at the trial court level of capital punishment, since a trial judge is more experienced in sentencing than a jury, and therefore is better able to impose sentences similar to those imposed in analogous cases. The Florida capital sentencing procedure thus seeks to assure that the death penalty will not be imposed in an arbitrary or capricious manner. Moreover, to the extent that any risk to the contrary exists, it is minimized by Florida's appellate review system, under which the evidence of the aggravating and mitigating circumstances is reviewed and reweighed by the Supreme Court of Florida, quote, to determine independently whether the imposition of the ultimate penalty is warranted, unquote. The Supreme Court of Florida, like that of Georgia, has not hesitated to vacate a death sentence when it has determined that the sentence should not have been imposed. Indeed, it has vacated 8 of the 21 death sentences that it has reviewed to date. Under Florida's capital sentencing procedures, in sum, trial judges are given specific and detailed guidance to assist them in deciding whether to impose a death penalty or imprisonment for life. Moreover, their decisions are reviewed to ensure that they are consistent with other sentences imposed in similar circumstances. Thus, in Florida, as in Georgia, it is no longer true that there is, quote, no meaningful basis for distinguishing the few cases in which the death penalty is imposed from the many cases in which it is not, unquote. On its face, the Florida system thus satisfies the constitutional deficiencies identified in Affirm. As in Gregg, the petitioner contends, however, that while perhaps facially acceptable, the new sentencing procedures in actual effect are merely cosmetic, and that arbitrariness and caprice still pervade the system under which Florida imposes the death penalty. The petitioner first argues that arbitrariness is inherent in the Florida criminal justice system because it allows discretion to be exercised at each stage of a criminal proceeding. The prosecutor's decision whether to charge a capital offense in the first place, his decision whether to accept a plea to a lesser offense, the jury's consideration of lesser included offenses, and, after conviction and unsuccessful appeal, the executive's decision whether to commute a death sentence. As we noted in Gregg, this argument is based on a fundamental misinterpretation of Affirm, and we reject it for the reasons expressed in Gregg. The petitioner next argues that the new Florida sentencing procedures in reality do not eliminate the arbitrary infliction of death that was condemned in Affirm. Basically, he contends that the statutory aggravating and mitigating circumstances are vague and overbroad, and that the statute gives no guidance as to how the mitigating and aggravating circumstances should be weighed in any specific case. Initially, the petitioner asserts that the enumerated aggravating and mitigating circumstances are so vague and so broad that virtually, quote, any capital defendant becomes a candidate for the death penalty, unquote. In particular, the petitioner attacks the 8th and 3rd statutory aggravating circumstances, which authorize the death penalty to be imposed if the crime is, quote, especially heinous, atrocious, or cruel, unquote, or if, quote, the defendant knowingly created a great risk of death to many persons, unquote. These provisions must be considered as they have been construed by the Supreme Court of Florida. That court has recognized that while it is arguable, quote, that all killings are atrocious, still we believe that the legislature intended something especially heinous, atrocious, or cruel when it authorized the death penalty for first-degree murder, unquote. As a consequence, the court has indicated that the 8th statutory provision is directed only at, quote, the conscienceless or pitiless crime which is unnecessarily torturous to the victim, unquote. We cannot say that the provision as so construed provides inadequate guidance to those charged with the duty of recommending or imposing sentences in capital cases. In the only case, except for the instant case, in which the third aggravating factor, quote, the defendant knowingly created a great risk of death to many persons, unquote, was found, the state Supreme Court held that the defendant created a great risk of death because he, quote, obviously murdered 2 of the victims in order to avoid a surviving witness to the first murder, unquote. As construed by the Supreme Court of Florida, these provisions are not impermissibly vague. The petitioner next attacks the imprecision of the mitigating circumstances. He argues that whether a defendant acted, quote, under the influence of extreme mental or emotional disturbance, unquote, whether a defendant's capacity, quote, to conform his conduct to the requirements of law was substantially impaired, unquote, or whether a defendant's participation as an accomplice in a capital felony was relatively minor, are questions beyond the capacity of a jury or judge to determine. He also argues that neither a judge nor a jury is capable of deciding how to weigh a defendant's age or determining whether he had a, quote, significant history of prior criminal activity, unquote. In a similar vein, the petitioner argues that it is not possible to make a rational determination whether there are sufficient aggravating circumstances that are not outweighed by the mitigating circumstances, since the state law assigns no specific weight to any of the various circumstances to be considered. While these questions and decisions may be hard, they require no more line drawing than is commonly required of a fact finder in a lawsuit. For example, juries have traditionally evaluated the validity of defenses such as insanity or reduced capacity, both of which involve the same considerations as some of the above-mentioned mitigating circumstances. While the various factors to be considered by the sentencing authorities do not have numerical weights assigned to them, the requirements of Affirm are satisfied when the sentencing authority's discretion is guided and channeled by requiring examination of specific factors that argue in favor of or against imposition of the death penalty, thus eliminating total arbitrariness and capriciousness in its imposition. The directions given to judge and jury by the Florida statute are sufficiently clear and precise to enable the various aggravating circumstances to be weighed against the mitigating ones. As a result, the trial court's sentencing discretion is guided and channeled by a system that focuses on the circumstances of each individual homicide and individual defendant in deciding whether the death penalty is to be imposed. Finally, the Florida statute has a provision designed to assure that the death penalty will not be imposed on a capriciously selected group of convicted defendants. The Supreme Court of Florida reviews each death sentence to ensure that similar results are reached in similar cases. Nonetheless, the petitioner attacks the Florida appellate review process because the role of the Supreme Court of Florida in reviewing death sentences is necessarily subjective and unpredictable. While it may be true that the court has not chosen to formulate a rigid objective test as its standard of review for all cases, it does not follow that the appellate review process is ineffective or arbitrary. In fact, it is apparent that the Florida court has undertaken responsibly to perform its function of death sentence review with a maximum of rationality and consistency. For example, it has several times compared the circumstances of a case under review with those of previous cases in which it has assessed the imposition of death sentences. By following this procedure, the Florida court has in effect adopted the type of proportionality review mandated by the Georgia statute, and any suggestion that the Florida court engages in only cursory or rubber stamp review of death penalty cases is totally controverted by the fact that it has vacated over 1/3 of the death sentences that have come before it. Florida, like Georgia, has responded to Affirm by enacting legislation that passes constitutional muster. That legislation provides that after a person is convicted of first-degree murder, there shall be an informed, focused, guided, and objective inquiry into the question whether he should be sentenced to death. If a death sentence is imposed, the sentencing authority articulates in writing the statutory reasons that led to its decisions. Those reasons and the evidence supporting them are conscientiously reviewed by a court which, because of its statewide jurisdiction, can assure consistency, fairness, and rationality in the even-handed operation of the state law. As in Georgia, this system serves to assure that sentences of death will not be wantonly or freakishly imposed. Accordingly, the judgment before us is affirmed. It is so ordered. So let's break down that opinion really quickly. Just as Lewis Powell says that Proffitt's initial argument was that the death penalty itself is unconstitutional, Powell refutes this and uses evidence from both Affirm v. Georgia Georgia and Gregg v. Georgia. In Furman v. Georgia, which was decided 4 years prior to this case, the court ruled that while the death penalty is not necessarily unconstitutional, it can cross over into unconstitutionality depending on what the sentencing procedures are and how it's applied. In Furman v. Georgia, the court held that Georgia's capital sentencing procedure was unconstitutional because it allowed for inconsistencies and discrepancies in who was sentenced to death and who was given a lesser sentence. Another outcome of that case was that many states who imposed the death penalty had to rework their capital sentencing procedure so as to remove the arbitrariness from the process. Attorney General Robert Shevin believes that Florida's new death penalty law, which Proffitt was tried under, fulfills the requirements established in Furman, and Justice Powell seems to agree with this. Writing for the court, Justice Powell says that the arbitrariness or capriciousness is removed from the sentencing procedure because the judge, who acts as the sole sentencing authority during the hearing to determine whether the defendant will receive life or death, is required not only to weigh 8 statutory aggravating factors against 7 statutory mitigating factors, but they must also provide a written explanation as to why they sentenced an inmate to death. Powell argues that the codified guidance of the aggravating and mitigating factors removes any capriciousness from the procedure. However, Justice Powell doesn't stop here. He recognizes that while a law on its face may not be unconstitutional, the way in which it's applied can be. However, he says that even here it is not applied in a manner that could be construed as unconstitutional. He says that since the Supreme Court of Florida automatically reviews death sentences, any unconstitutional application of the law would surely be discovered by the Supreme Court of Florida. If you remember, though, Clinton Curtis brought up the point that those sentenced to life in prison have their sentences reviewed by the District Court of Appeals, as well as the fact that the justices don't give a written explanation explaining why they sentenced a prisoner to life. Curtis used this as an argument to point out the unconstitutional application of the law by basically saying that since Charles Proffitt was being sentenced differently than somebody who received life, that his 14th Amendment rights were being violated. However, Justice Powell denies this argument as well. Powell refutes the latter of Curtis's claims by citing Shevin's argument that judges who sentence defendants to life are in fact required to provide a written explanation as to how they came to their decision, complete with a citation of the statutory mitigating and or statutory aggravating circumstances they found. Furthermore, Powell says that the Supreme Court of Florida can and has looked to these life imprisonment cases and compared them to death sentence cases, and in the event that they find a prisoner who was sentenced to death when another prisoner who is acting under similar circumstances was sentenced to life, they then lower the first prisoner's sentence down to life as well, thus defeating Curtis's 14th Amendment argument. Another thing that Powell points out is the fact that the sentencing procedures are different in Florida and Georgia. In Georgia, the jury decides whether or not a prisoner receives the death penalty. However, in Florida, the jury's purpose is solely advisory. Powell makes the argument that, if anything, Florida's sentencing procedure provides for more consistency in who gets death than Georgia's procedure. This is because if you use the jury system that's used in Georgia, different defendants will be given different juries who could return different verdicts. In Florida, however, it's the same judge making the decision. In fairness, though, it's only the same judge per district, but Powell doesn't address this point. Next up is the concurring opinion authored by Justice Byron White and joined by Chief Justice Burger as well as Justice Reinquist. That opinion is as follows. There is no need to repeat the statement of the facts of this case and of the statutory procedure under which the death penalty was imposed, both of which are described in detail in the opinion of Mr. Justice Stewart, Mr. Justice Powell, and Mr. Justice Stevens. I agree with them that although the statutory aggravating and mitigating circumstances are not susceptible of mechanical application, they are by no means so vague and overbroad as to leave the discretion of the sentencing authority unfettered. Under Florida law, the sentencing judge is required to impose the death penalty on all first-degree murderers as to whom the statutory aggravating factors outweigh the mitigating factors. There is good reason to anticipate, then, that as to certain categories of murderers, the penalty will not be imposed freakishly or rarely, but will be imposed with regularity, and consequently it cannot be said that the death penalty in Florida as to those categories has ceased, quote, to be a credible deterrent or measurably to contribute to any other end of punishment in the criminal justice system, unquote. Accordingly, the Florida statutory scheme for imposing the death penalty does not run afoul of this court's holding in Furman v. Georgia. For the reasons set forth in my opinion concurring in the judgment in Gregg v. Georgia and my dissenting opinion in Roberts v. Louisiana, this conclusion is not undercut by the possibility that some murderers may escape the death penalty solely through exercise of prosecutorial discretion or executive clemency. For the reasons set forth in my dissenting opinion in Roberts v. Louisiana, I also reject petitioner's argument that under the Eighth Amendment the death penalty may never be imposed under any circumstances. I concur in the judgment of affirmance. So, in that opinion, Justices White, Berger, and Reinquist are basically saying that yes, they agree that while the death penalty may be applied in an unconstitutional manner, it was not done in this case. They also go even further and say that they reject the argument that the death penalty is inherently in contravention to the Eighth Amendment. Finally, the last concurring opinion comes from Justice Harry Blackman, who said simply, "I concur in the judgment, see Furman v. Georgia." There isn't really much to unpack here. He just says, I agree with this ruling, and I said what I needed to say in the Furman case, so just look at that. So, now that we're done with the concurring opinions, let's look at the dissenting opinions. If you recall, this case was a part of a larger group of cases nicknamed the death penalty cases, and in each of those cases, Justices Brennan and Marshall both dissented, and they just used the same dissent for pretty much all of the death penalty cases. So the first dissent we'll look at is Justice Brennan's dissent. He says, "The cruel and unusual punishments clause, quote, must draw its meaning from the evolving standards of decency that mark the progress of a maturing society," unquote. The opinions of Mr. Justice Stewart, Mr. Justice Powell, and Mr. Justice Stevens today hold that evolving standards of decency require focus not on the essence of the death penalty itself, but primarily upon the procedures employed by the state to single out persons to suffer the penalty of death. Those opinions hold further that, so viewed, the clause invalidates the mandatory infliction of the death penalty, but not its infliction under sentencing procedures that Mr. Justice Stewart, Mr. Justice Powell, and Mr. Justice Stevens conclude adequately safeguard against the risk that the death penalty was imposed in an arbitrary and capricious manner. In Furman v. Georgia, I read evolving standards of decency as requiring focus upon the essence of the death penalty itself, and not primarily or solely upon the procedures under which the determination to inflict the death penalty upon a particular person was made. I there said, quote, "From the beginning of our nation, the punishment of death has stirred acute public controversy. Although pragmatic arguments for and against the punishment have been frequently advanced, this long-standing and heated controversy cannot be explained solely as the result of differences over the practical wisdom of particular government policy. At bottom, the battle has been waged on moral grounds. The country has debated whether a society for which the dignity of the individual is the supreme value can, without a fundamental inconsistency, follow the practice of deliberately putting some of its members to death. In the United States, as in other nations of the Western world, the struggle about this punishment has been one between ancient and deeply rooted beliefs in retribution, atonement, or vengeance on the one hand, and on the other, beliefs in the personal value and dignity of the common man that were born of the democratic movement of the 18th century, as well as beliefs in the scientific approach to an understanding of the motive forces of human conduct, which are the result of the growth of the sciences of behavior during the 19th and 20th centuries. It is this essentially moral conflict that forms the backdrop for the past changes in and the present operation of our system of imposing death as a punishment for crime," unquote. That continues to be my view. For the clause forbidding cruel and unusual punishments under our constitutional system of government embodies in unique degree moral principles restraining the punishments that our civilized societies may impose on those persons who transgress its laws. Thus, I too say, quote, "For myself, I do not hesitate to assert the proposition that the only way the law has progressed from the days of the rack, the screw, and the wheel is the development of moral concepts, or, as stated by the Supreme Court, the application of evolving standards of decency," unquote. This court inescapably has the duty, as the ultimate arbiter of the meaning of our Constitution, to say whether, when individuals condemned to death stand before our bar, moral concepts require us to hold that the law has progressed to the point where we should declare that the punishment of death, like punishments on the rack, the screw, and the wheel, is no longer morally tolerable in our civilized society. My opinion in Furman v. Georgia concluded that our civilization and the law had progressed to this point, and that therefore the punishment of death, for whatever crime and under all circumstances is cruel and unusual in violation of the 8th and 14th Amendments of the Constitution. I shall not again canvass the reasons that led to that conclusion. I emphasize only that the foremost among the moral concepts recognized in our cases and inherent in the clause is the primary moral principles that the state, even as it punishes, must treat its citizens in a manner consistent with their intrinsic worth as human beings. A punishment must not be so severe as to be degrading to human dignity. A judicial determination whether the punishment of death comports with human dignity is therefore not only permitted but compelled by the clause. I do not understand that the court disagrees that, quote, in comparison to all other punishments today, the deliberate extinguishment of human life by the state is uniquely degrading to human dignity, unquote. For 3 of my brethren hold today that mandatory infliction of the death penalty constitutes the penalty cruel and unusual punishment. I perceive no principled basis for this limitation. Death for whatever crime and under all circumstances is truly an awesome punishment. The calculated killing of a human being by the state involves by its very nature a denial of the executed person's humanity. An executed person has indeed lost the right to have rights. Death is not only an unusually severe punishment, unusual in its pain, in its finality, and in its enormity, but it serves no penal purpose more effectively than a less severe punishment. Therefore, the principle inherent in the clause that prohibits pointless infliction of excessive punishment when less severe punishment can adequately achieve the same purpose invalidates the punishment. The fatal constitutional infirmity in the punishment of death is that it treats, quote, members of the human race as non-humans, as objects to be toyed with and discarded. It is thus inconsistent with the fundamental premise of the clause that even the vilest criminal remains a human being possessed of common human dignity, unquote. As such, it is a penalty that, quote, subjects the individual to a fate forbidden by the principle of civilized treatment guaranteed by the clause, unquote. I therefore would hold on that ground alone that death is today a cruel and unusual punishment prohibited by the clause. Quote, justice of this kind is obviously no less shocking than the crime itself and the new official murder. Far from offering redress for the offense committed against society, adds instead a second defilement to the first, unquote. I dissent from the judgments in Gregg v. Georgia, Proffitt v. Florida, and Jurek v. Texas insofar as each upholds the death sentences challenged in those cases. I would set aside the death sentences imposed in those cases as violative of the 8th and 14th Amendments. So, in Justice Brennan's dissent, he makes 2 main points. The first is that, when answering the 8th Amendment questions, it is the job of the court to determine whether or not a treatment that a prisoner is receiving is cruel and unusual in the scope of societal standards at the time. Brennan brings up the example of the wheel, which was a torture method. He said that the wheel used to be used on prisoners and it wasn't considered cruel when it was used. However, as people evolve and as their thinking changes, so does their idea of what is or isn't cruel. Thus, eventually people came to see torture upon prisoners as a cruel and unusual punishment. Brennan argues that we are now at a point in our world where our thinking has progressed so much that it's high time that we all realize that the death penalty is a cruel and unusual punishment. Justice Brennan also brings up the point that sentencing prisoners to death doesn't deter any more criminals from committing a crime than a life sentence would. He argues that since there is a lesser punishment that effectuates the same purpose, that the death penalty is therefore inherently cruel and unusual. Now let's take a look at Justice Marshall's dissent. He says, in Affirm v. Georgia, I set forth at some length my views on the basic issue presented to the court in these cases. The death penalty, I concluded, is a cruel and unusual punishment prohibited by the 8th and 14th Amendments. That continues to be my view. I have no intention of retracing the long and tedious journey that led to my conclusion in Affirm. My sole purposes here are to consider the suggestion that my conclusion in Affirm has been undercut by developments since then, and briefly to evaluate the basis for my brethren's holding that the extinction of life is a permissible form of punishment under the Cruel and Unusual Punishments Clause. In Affirm, I concluded that the death penalty is constitutionally invalid for 2 reasons. First, the death penalty is excessive, and second, the American people, fully informed as to the purposes of the death penalty and its liabilities, would, in my view, reject it as morally unacceptable. Since the decision in Affirm, the legislatures of 35 states have enacted new state statutes authorizing the imposition of the death sentence for certain crimes, and Congress has enacted a law providing the death penalty for air piracy resulting in death. I would be less than candid if I did not acknowledge that these developments have a significant bearing on a realistic assessment of the moral acceptability of the death penalty to the American people. But if the constitutionality of the death penalty turns, as I have urged, on the opinion of an informed citizenry, then even the enactment of the new death penalty statutes cannot be viewed as conclusive. In Furman, I observed that the American people are largely unaware of the information critical to a judgment on the morality of the death penalty, and concluded that if they were better informed, they would consider it shocking, unjust, and unacceptable. A recent study conducted after the enactment of the post-Furman statutes has confirmed that the American people know little about the death penalty and that opinions of an informed public would differ significantly from those of a public unaware of the consequences and effects of the death penalty. Even assuming, however, that the post-Furman enactment of statutes authorizing the death penalty renders the prediction of the views of an informed citizenry an uncertain basis for a constitutional decision, the enactment of those statutes has no bearing whatsoever on the conclusion that the death penalty is unconstitutional because it is excessive. An excessive penalty is invalid under the cruel and unusual punishments clause, quote, even though popular sentiment may favor it, unquote. The inquiry here, then, is simply whether the death penalty is necessary to accomplish the legitimate legislative purposes in punishment, or whether a less severe penalty of life imprisonment would do as well. The two purposes that sustain the death penalty as non-excessive in the court's view are general deterrence and retribution. In Furman, I canvassed the relative data on the deterrent effect of capital punishment. The state of knowledge at that point, after literally centuries of debate, was summarized as follows by a United Nations committee. Quote, it is generally agreed between the retentionists and the abolitionists, whatever their opinions about the validity of comparative studies of deterrence, that the data which now exist show no correlation between the existence of capital punishment and lower rates of capital crime. The available evidence, I concluded in Furman, was convincing that capital punishment is not necessary as a deterrent to crime in our society. The Solicitor General in his amicus brief in these cases relies heavily on a study by Isaac Ehrlich, reported a year after Furman, to support the contention that the death penalty does deter murder. Since the Ehrlich study was not available at the time of Furman, and since it is the first scientific study to suggest that the death penalty may have a deterrent effect, I will briefly consider its import. The Ehrlich study focused on the relationship in the nation as a whole between the homicide rate and execution risk, the fraction of persons convicted of murder who were actually executed. Comparing the differences in homicide rate and execution risk for the years 1933 to 1969, Ehrlich found that increases in execution risk were associated with increases in the homicide rate. But when he employed the statistical technique for multiple regression analysis to control for the influence of other variables posited to have an impact on the homicide rate, Ehrlich found a negative correlation between changes in the homicide rate and changes in execution risk. His tentative conclusion was that for the period from 1933 to 1967, each additional execution in the United States might have saved 8 lives. The methods and conclusions of the Ehrlich study have been severely criticized on a number of grounds. It has been suggested, for example, that the study is defective because it compares execution and homicide rates on a nationwide rather than a state-by-state basis. The aggregation of data from all states, including those that have been abolished the death penalty, obscures the relationship between murder and execution rates. Under Ehrlich's methodology, a decrease in the execution risk in one state combined with an increase in the murder rate in another state would, all other things being equal, suggest a deterrent effect that quite obviously would not exist. Indeed, a deterrent effect would be suggested if, once again, all other things being equal, one state abolished the death penalty and experienced no change in the murder rate, while another state experienced an increase in the murder rate. The most compelling criticism of the Ehrlich study is that its conclusions are extremely sensitive to the choice of time period included in the regression analysis. Analysis of Ehrlich's data reveals that all empirical support for the deterrent effect of capital punishment disappears when the 5 most recent years are removed from his time series, that is to say, whether a decrease in the execution risk corresponds to an increase or a decrease in the murder rate depends on the ending point of the sample period. This finding has cast severe doubts on the reliability of Ehrlich's tentative conclusions. Indeed, a recent regression study based on Ehrlich's theoretical model but using cross-section state data for the years 1950 and 1960 found no support for the conclusion that executions act as a deterrent. The Ehrlich study, in short, is of little, if any, assistance in assessing the deterrent impact of the death penalty. The evidence I reviewed in Furman remains convincing in my view that, quote, capital punishment is not necessary as a deterrent to crime in our society. The justification for the death penalty must be found elsewhere. The other principal purpose said to be served by the death penalty is retribution. The notion that retribution can serve as moral justification for the sanction of death finds credence in the opinion of my brothers Stewart, Powell, and Stevens, and that of my brother White in Roberts v. Louisiana. It is this notion that I find to be the most disturbing aspect of today's unfortunate decisions. The concept of retribution is a multifaceted one, and any discussion of its role in the criminal law must be undertaken with caution. On one level, it can be said that the notion of retribution or reprobation is the basis of our insistence that only those who have broken the law be punished, and in this sense the notion is quite obviously central to a just system of criminal sanctions. But our recognition that retribution plays a crucial role in determining who may be punished by no means requires approval of retribution as a general justification for punishment. It is the question whether retribution can provide a moral justification for punishment, in particular capital punishment, that we must consider. My brothers Stewart, Powell, and Stevens offer the following explanation of retributive justification for capital punishment. Quote, "The instinct for retribution is part of the nature of man, and channeling that instinct in the administration of criminal justice serves an important purpose in promoting the stability of a society governed by law. When people begin to believe that organized society is unwilling or unable to impose upon criminal offenders the punishment they deserve, then there are sown the seeds of anarchy, of self-help, vigilante justice, and lynch law." Unquote. This statement is wholly inadequate to justify the death penalty. As my brother Brennan stated in Affirm, quote, "There is no evidence whatsoever that utilization of imprisonment rather than death encourages private blood feuds and other disorders." Unquote. It simply defies belief to suggest that the death penalty is necessary to prevent the American people from taking the law into their own hands. In a related vein, it may be suggested that the expression of moral outrage through the imposition of the death penalty serves to reinforce basic moral values, that it marks some crime as particularly offensive and therefore to be avoided. The argument is akin to a deterrence argument, but differs in that it contemplates the individual shrinking from antisocial conduct, not because he fears punishment, but because he has been told in the strongest possible way that the conduct is wrong. This contention, like the previous one, provides no support for the death penalty. It is inconceivable that any individual concerned about conforming his conduct to what society says is right would fail to realize that murder is wrong if the penalty were simply life imprisonment. The foregoing contentions that society's expression of moral outrage through the imposition of the death penalty preempts the citizenry from taking the law into its own hands and reinforces moral values are not retributive in the purest sense. They are essentially utilitarian in that they portray the death penalty as valuable because of its beneficial result. These justifications for the death penalty are inadequate because the penalty is, quite clearly I think, not necessary to the accomplishments of those results. There remains for consideration, however, what might be termed the purely retributive justification for the death penalty, that the death penalty is inappropriate not because of its beneficial effect on society, but because the taking of the murderer's life is itself morally good. Some of the language of the opinion of my brothers Stewart, Powell, and Stevens appears positively to embrace this notion of retribution for its own sake as a justification for capital punishment. They state, quote, "The decision that capital punishment may be the appropriate sanction in extreme cases is an expression of the community's belief that certain crimes are themselves so grievous an affront to humanity that the only adequate response may be the penalty of death." They then quote with approval from Lord Justice Denning's remarks before the British Royal Commission on Capital Punishment. "The truth is that some crimes are so outrageous that society insists on adequate punishment because the wrongdoer deserves it, irrespective of whether it is a deterrent or not." Unquote. Of course, it may be that these statements are intended as no more than observations as to the popular demands that it is thought must be responded to in order to prevent anarchy. But the implication of the statements appears to me to be quite different. Namely, that society's judgment that the murderer quote-unquote deserves death must be respected not simply because the preservation of order requires it, but because it is appropriate that society make the judgment and carry it out. It is this latter notion in particular that I consider to be fundamentally at odds with the Eighth Amendment. The mere fact that the community demands the murderer's life in return for the evil he has done cannot sustain the death penalty. For as Justices Stewart, Powell, and Stevens remind us, the Eighth Amendment demands more than that a challenged punishment be acceptable to contemporary society. To be sustained under the Eighth Amendment, the death penalty must quote, comport with the basic concept of human dignity at the core of the amendment, unquote. The objective in imposing it must be, quote, consistent with our respect for the dignity of other men, unquote. Under these standards, the taking of life, because the wrongdoer deserves it, surely must fall, for such a punishment has as its very basis the total denial of the wrongdoer's dignity and worth. The death penalty, unnecessary to promote the goal of deterrence or to further any legitimate notion of retribution, is an excessive penalty forbidden by the 8th and 14th Amendments. I respectfully dissent from the court's judgment upholding the sentences of death imposed upon the petitioner in these cases. So Justice Marshall brings up 3 points that he says brought him to his dissent. The first point is the same that Justice Brennan mentioned. They both believe that the death penalty doesn't do an adequate job of deterring crime, and they both believe that a life sentence would have the same effect as the death penalty in terms of acting as a deterrent. Justice Marshall also offers another refutation of the death penalty by saying that even if the people support the death penalty, the government is under no obligation to perform the death penalty or any other punishment that is cruel or unusual. Lastly, Justice Marshall concludes that the death penalty is an ineffective form of retribution because it removes the last shred of dignity that a defendant has, thus violating the 8th Amendment. So there it is, a 7-2 decision in favor of affirming Charles Proffitt's death sentence. However, the aftermath of the case is pretty interesting. As for Charles, he appealed once more to the Supreme Court of Florida, and this time they overturned his conviction and granted him a new trial. In 1987, the new trial resulted in him receiving a life sentence. He remained an imprisoned man until his death in February of 2012. As for the Supreme Court case, the opinion for Proffitt was delivered alongside opinions for several other death penalty cases, and this group of cases is known today as the death penalty cases. These cases reinstated the death penalty in the United States because in 1972, the Supreme Court case Affirm v. Georgia imposed a moratorium on the death penalty in the U.S. The precedent set in the death penalty cases was that the death penalty is not necessarily unconstitutional, but in certain instances, the way it's applied can be. That has been the ruling precedent on the death penalty in the U.S. The most recent death penalty case to be decided by the Supreme Court is McKinney v. Arizona, which was decided in February of 2020. Well, that's going to be it for this episode of On the Docket. If you enjoyed it, please leave a like, and if you want to be here for the next one, please subscribe. Thank you, and goodbye.